Yes, be nice to us. We are lawyers, and lawyers can be your friends, and you just have to know how to work with us effectively and know how to use us, what we can help you with, and what you need to look elsewhere. And being specific, but we'll talk about that at the end. My name is Renee. I've been practicing for 28 years. The focus of my practice for most of those 28 years has been representing small and medium-sized businesses. Everything from incorporating, getting them started, to selling them to large companies down the line, and everything that happens in between, from employment, creating agreements, restrictive covenants, buying and selling assets, businesses, leasing, and vendor disputes. So contracts of all different natures and types. So that's my general experience. And I have with me Laura Rogel, who's been practicing about 7 years. And her practice also is working with businesses, but her primary focus is intellectual property. And I'll let Laura discuss a little bit more about what she does with this. And most of the presentation will actually be by Laura. We encourage questions. We don't want to be talking heads. We want to interact with you. It's our view that as lawyers, we are collaborating with you. We are a business tool. And in that vein, we need to be working together and not just telling you what you can and cannot do, but helping you find solutions to your problems. That's ultimately, as lawyers, what we try to do. We have a couple of handouts and other materials for you today. We have the handout on Do You Know What Your Company Owns? A little flyer on Arizona's business law firm of J. Bergen Wolf. Protecting your art and photographs. Protect your image. Copyright quick tips. And an article by one of our partners called Advanced Planning Can Keep Your New Business Partnerships Amicable. And we'll talk a little bit more about that topic today as well. We have our business cards. And we also have J. Bergen Wolf screen cleaner cloths. For whatever reason we have it. So, all right, with that, I'm going to turn it over to Laura, but we're happy to answer any questions, and I'll come back in on more of the business issues. I'm Renee Gerstmann, and this is Laura Rogel.
Okay, I'm going to stand down here so you guys can see our slide. It apparently doesn't like the fact that I made it in 2010 and I'm now showing it in 2007. So some of our content apparently doesn't want to show up, which is fine. What we're basically here to talk about is protecting your ideas and how the best way of going about protecting your ideas is. You guys are working in a collaborative environment. You can go talk to whomever, ask questions of everyone, and you're bouncing ideas off of each other. The problem arises, and where we come into play, is when you have an idea and you share that idea with someone else, and then someone else thinks it's their idea, or they think that you guys have created an idea together. And what we want to do is we want to make sure that everyone understands the best ways to protect and preserve what your own ideas are, and to monetize those ideas in the best way possible for your own personal business or your own personal brand. So the first thing that we're going to start with is just what is an idea, right? There's tons and tons and tons of different ways to define an idea. I only put down the first 5. There were actually 8 that dictionary.com came up with. But the best and most important thing for you to realize is that you can protect an idea. Just because you've come up with something and you haven't created some sort of tangible physical item or object doesn't mean that there isn't some sort of protection legally that's available for you. And so knowing what those protections are and how to go about managing and establishing those protections and putting those protections in place before you go forward means that you don't have to come to us at the end of the day and go, oh my gosh, this person's, I had this idea, I put it on a napkin at Starbucks, and then 6 months later, HBO is showing my TV show that I came up with, or something like that. I've actually had that phone call. So we want you to understand all of these different ideas and concepts that are available to protect your own business program. All of this boils down to the concept of intellectual property. Does anyone know what intellectual property is, what it means? Anyone? Interactive presentation? Okay, what do you think it is? So, intellectual property. Everything that you guys are doing here pretty much is intellectual property, right? I mean, you're basically creating ideas, creating work, creating constructs. All of that constitutes intellectual property. And there are different types of intellectual property that we're going to go into, we're going to talk about. We're going to talk about what I call the big five of intellectual property. We're going to talk about trademarks, copyrights, patents, trade dress, and trade secrets. And that's sort of the big all-consuming ideas of intellectual property. And just know that all of these are protectable items. These are all things that you are able to protect under the law and that you have certain rights to. So the first thing that we'll talk about is a trademark. A trademark is a brand name. It can include lots and lots and lots of different things. Trademark can be done in two ways. It can be just what's called a word mark, so just the name Gangplank, but it can also be the design that Gangplank is written in. So the fonts included with the logo, that whole combination of things, that can also be registered as a trademark. There's lots of benefits to registering trademarks. There's two places that you can register a trademark. You can register a trademark with the Arizona Secretary of State. That just covers the state of Arizona. Registering your trademark with the Arizona Secretary of State doesn't do a whole lot. The good news is it costs like $35, so it doesn't cost you a whole lot of money to do it. The bad news is that your enforcement mechanisms with having a trademark registered in the state of Arizona doesn't get you very far if you have to sue someone for using your trademark. Registering your trademark with the USPTO, the United States Patent and Trademark Office, is much more effective, and it gives you a vast amount more rights, including putting people on notice that you are actually using this trademark. Trademarks are great. There's a lot of different ways that you can utilize and leverage your trademark. Registering a trademark doesn't cost all that much. You can do it on your own. It's not that difficult to do. There are lots of forms and packets on the USPTO's website that literally walk you through step by step of the process. Where people screw up is understanding what a trademark is to begin with. So there's two ways you can register a trademark. You can register a trademark that you're already using. You can also register a trademark under what's called an intent to use. So let's say you've got an idea and you think of this brilliant name that goes along with your idea. You're months or years away from launch. You can go ahead and register the trademark that goes along with that idea in order to preserve and protect and make sure that no one else is going to steal that brilliant name that you came up with for your business product or service or whatever it is that you're registering it for. So you can actually register a trademark in advance of launching a product or a service. The good thing about that is that you're not spending tens of thousands of dollars on marketing, branding, and things like that on something that isn't protectable, right? We see that all the time where people will come in and they're like, oh, but I already launched and I did this, 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 and this, and I have a website and I have promo materials and we're doing this show, and that's great, but someone else already registered that trademark and has been using it. So you've now wasted all of this time and money and effort on branding a product or a service that you can't use. You're going to have to change your name because they've been using it in commerce longer than you have. So you can registering that for an intent to use is really helpful. Again, still not that expensive, and it allows you to sort of develop your concept while still preserving that intellectual property of the trademark. The other registration, obviously, is if you've already started using something, you can register something that's already being used. You do have to submit a specimen to the USPTO. It just shows that it's being used in commerce. So a screenshot of your website, a label on a bottle, something along those lines, those all count as specimens. It's very simple and easy to do. It allows you then to protect your trademark. And so by protecting your trademark, you can go out and enforce the trademark rights that you have against other people who might be using similar phrasing. So for example, we have a client who, she's involved in the organizational services, which you know, it seems relatively innocuous. She does like closet organizing and life organization and things like that. But for whatever reason, the name that she picked, people all over the country are using. Well, she was smart enough to register her trademark early on. So what we've been able to do is we've been able to get probably 15 different businesses across the United States to have to stop using their name because their name is confusingly similar to the name of our client's business out here. And that's done usually most effectively by just doing a simple demand letter. People get a demand letter from a lawyer and they freak out because lawyers are mean and evil, and we send very threatening, scary letters, and people are like, whoa, I don't want to deal with this anymore. I'm just gonna run away screaming. And that's fine. You don't usually have to sue someone to get them to stop using a trademark. There's other ways also to get people to stop using a trademark other than suing. There's actually an administrative process through the USPTO that you can go through to get people to stop using a trademark there as well. Third reason why registering a trademark is good is to, although it doesn't happen as much nowadays, is to avoid domain name squatting. If someone has registered your trademark as a domain name and is redirecting traffic to a competitor, that's cyber squatting. It's a violation of federal law. All you have to do is send a letter to their host or their registrar and say, hey, they're doing this, this is a violation, and they'll usually shut down the site. And sometimes they'll even give the site back to you. If that doesn't work, you can do UDRP action. Anyone know what that is? Okay, I figured I would pause for a second and see if anyone was catching up with me. UDRP is a Uniform Domain Name Dispute Resolution Program policy. Sorry. So if you have a dispute over a domain name, there's actually administrative bodies that will resolve those disputes. So if someone's using the domain name that's your trademark or your business, you can go through that. It's cheaper than going through the courts. It's like $1,500 for the whole process. And it allows you to get that resolved and get the domain name transferred back to you as the rightful owner. Some of the benefits of trademarks. Anyone have any questions about trademarks? Because we did like the super speedy overview. Yes?
So I just wanted to clarify. The intent to use, that category, so say for example, I have, say, an idea, and as you gave an example, if I have a name for my business that I want to launch in the future, let's say I haven't developed like a logo or any graphic, any representation, so I can still go ahead and just trademark just the combination of that.
Yes, because
there's the business name.
Yeah, and so what it's really like a pending registration. So you're kind of, it's an intent to use as a hold. So you've got a hold on that name.
Okay.
And they give you 2 years to submit proof of use.
Okay, so at that time I can say in 2 years I've developed the promo materials, the graphics, all that
Exactly.
stuff. Then I can put it back.
Exactly, and then it'll go through the official registration process at that point in time.
Okay.
But think of it as like a placeholder. The intent to use is kind of like a placeholder. No one else can take it while you have that intent to use application with the USPTO. So it's nice because like you said, it gives you the opportunity to develop it. You don't have to have a logo. Trademark doesn't have to be stylized in any way, shape, or form. It can just be a name. It can just be words. There's 2 versions of trademarks, the stylized and the non-stylized. So if you have a name and you have an ID attached to it and you're like, this is an awesome name and someone's gonna take this if I don't get it going, absolutely, that's the easiest, most efficient way to get that started and protected. And eventually, if you don't end up using it, it's just an abandoned mark. So it doesn't cost you anything. You don't get penalized if you don't end up registering the trademark. It just kind of hangs out there and sort of dies its natural death at the end of the day.
So how does that go along with like registering a company and the company name?
So
That's completely different, right?
completely different.
So just because I have a name doesn't mean I have right to using that.
Absolutely.
Company.
So the Arizona Corporation Commission does not check any other records other than their own records to see if a name exists. So you can have 16 companies all using the same name registered with the Corporation Commission, as long as there's an Inc. or an LLC or an A or a B or a C or a 2, somewhere in that name, you can have 15 sort of derivatives of the same name business on the Corporation Commission. And that doesn't mean you have any rights whatsoever under trademark law to use that name in business. It just means that the Arizona Corporation looked at their list and they said, okay, there's no one else using this exact same version of this name, so you can do it. Same with the Arizona Secretary of State, and that goes back to what I was talking about earlier. Registering with the Arizona Secretary of State doesn't mean that you have any right to use it, because they don't do a search to say, oh, there's someone else in Nevada or California or Omaha that's using this business name. They just say, oh, is someone else in Arizona registered it? No, here you go. Same with the thing with the trade name. You can register a trade name with the Secretary of State. It doesn't give you a whole lot more rights. It gives you a little bit of protection in business interest, and Renee will talk about that later on, sort of explaining how you're going to want to use businesses to help protect your personal interests and liabilities in that way. But it doesn't give you any type of extra intellectual property right. It just means that you spent like the $35 and filled out a piece of paper.
Okay. And so also with the trademark, you can force, you were talking about sending the demand letter.
Mm-hmm.
You can have people, does that work for people who have businesses that have similar but not identical?
Depends if they're in the same area of business, and so you have to be relatively in the same stream of commerce. So let's say there's, Gangplank registers its trademark for co-working space, incubators, that sort of environment. Someone else registers Gangplank dry cleaners. They're completely different services and completely different entities, so there's not going to be a conflict there. There's no what the courts look for and what the USPTO looks for is what's called likelihood of confusion. So if a consumer is looking at the name of the business, are they going to think that this Gangplank, the co-working space, is the same as the Gangplank dry cleaners? And there's not really going to be a likelihood of confusion there because there's completely separate business entities. If you have a co-working space and an incubator, those are very similar. People don't even know the differences half the time. And so that they would probably say, okay, that's way too close. There's a huge likelihood of consumer confusion here. We're not going to allow those type of registrations. Any other questions on trademarks, or we're going to jump right into copyrights? How come no one else is excited about copyrights as I am? Come on, copyright.
I do have a question about trademarks.
Yes.
So if you have say a camp or an event or something that you are going to possibly expand on in the future, talking about intent, would you want to trademark the tagline on that, and can you do it? Do you do that as like an individual, or do you have to put that under?
Okay,
if
so
that's not an official business, but
you can do
might be a permanent.
You can do it however you want. So you're going to have to look at your business structure first to decide what's the best way to do it. So we have some people, I would say our clients are probably split about 50-50. I have some people who registered in their individual name and then they license that trademark to the business. The problem is if the business is the one that's using it, the business is the one that should be registering it as the trademark. Because it is that intellectual property like we're talking about, and intellectual property does have value, which Renee will go into as I have a graphic with a money machine and it's very cute and exciting. No one cares. So it depends on who's going to be using it. But if you said you already had an event, you used the event once, that's enough. You wouldn't register it under an intent to use. If you have a tagline from an event that you already had and you're planning on expanding that event to monthly programming or something along those lines, you've already used it once. You can register it as a current use.
Okay.
So you wouldn't have to do it on a going forward basis.
But it would be registered under, I guess my question is, if that eventually would become a business of itself,
Yeah.
rather than a part of the original business.
And you can also transfer trademark interest. So like let's say you register it yourself, and then the business grows and develops, and you've decided, okay, this isn't really my thing anymore. This is really the business thing. You can just assign it to the business. So the transferability of trademarks is really easy. There's just a form online, and I think there's like a small charge associated with it, but it's not difficult to assign it. So you're not stuck in the first thing that you pick. You're stuck with the trademark, but you're not stuck with who owns it. Just like you can change attorneys.
And we'll do a little change here. And that's one of the things that we can talk about. And in terms of business issues, there's so many, we'll look for feedback on what you want to hear about. But one of the things that we come up against fairly frequently is people are buying and selling businesses or assets for businesses. And trademarks and copyrights and intellectual property are something that needs to be considered when you're either creating some kind of partnership a new business or selling your business. So that is one of the issues on transferability. So you may want to keep it separate for some reason. And again, as Laura said, there may be issues as whether it's a license or if you're licensing it to other people, and it's not exclusively used by one company, then that would also be an issue as to how you want to have it trademarked. So just think about it. Is it something that is exclusively used by a company, or is it something that somebody else can also license?
Well, and for trademarks and copyright licensing are very different. Trademark, you're not really going to want to license a trademark, right? You can license it to a single business, but one of the things that we look to for protectability of a trademark is dilution. So is it being used in 16 different places by 16 different businesses, you lose the strength of that mark, and then you lose your ability to enforce it. Copyrights, which is our next slide, the protection of an idea or an artistic work or any kind of work really, copyright licensing is very, very typical, very usual, and that's something that happens all the time, and that's probably something that all of you should be doing depending on the type of work that you're doing here, but for the most part, you will probably be licensing copyrights or stealing someone's copyright and not even knowing it, which we frown upon as lawyers. This is the definition from the US, or from copyright.gov. Copyrights protect artistic works such as songs, poems, and paintings, but they can also protect content on a website and any written or graphic works that might have been created for a business. So as you see, it's pretty all-consuming. Copyrights pretty much cover anything that you create that's a drawing, a writing, a video, an audio, a website, a graphic. Pretty much anything that you create is going to be covered, arguably, by copyright. So, show of hands. Who here thinks that it's okay to take a graphic from Google Images and use it on your own website?
Transform it significantly.
There you go. Good answer. Fair use. Yes, lots of people learn copyright after they get a mean, nasty copyright demand letter from typically a copyright troll, which, whereas their lawyers, should not be associated with us. Copyright, almost everything that you do is going to have a copyright associated with it. The registration of a copyright only means that you're entitled to certain extra damages and fees if you sue someone. But the fact that you don't register a copyright doesn't mean that you have any less rights in the work that you created, which is an important thing to remember. So, if you take a picture, you as the photographer are the owner of the copyright of that photo. Not the person who's in the picture. The person who's in the picture has absolutely no rights, for the most part. Unless they're in California and a celebrity, but that's a different issue for a different day. But you, yes?
But don't you have to get clearance, say it's filed or something like that?
It depends. If they're out in public, no. You technically don't. As a CYA, lots of newspapers and media organizations will do that. But if you are out in public, you have zero expectation of privacy and zero expectation that you will not have your picture taken. So, if a parent doesn't want their child photographed ever, keep them at home and don't ever let them out, because that's really the only way that you can preserve that. But so, as a copyright owner of the picture, let's say you take a picture, you post it online. Someone takes that picture, they're like, wow, that's a really cool picture of a sunset on a beach. That would be great in my advertisement for suntan lotion. They take that picture, they use it in their advertisement. They've now violated, they've infringed on your copyright. You're entitled to damages from them. If you have that picture registered, you're entitled to statutory damages. It can run from $750,000 to $350,000, depending on the work, how much it was used, that sort of thing. If you haven't registered it, it's what's called basically like a license value. Not so much, there's not like a fixed number attached to it, but you're still entitled to something as damages. You can also, the good thing about copyrights is you can register it after the fact. So let's say you take a picture, someone uses it, you sue them, you can register it, and then it still counts as having been registered for purposes of suing them. There's that little loophole in the copyright law. Yes?
What about computer code, software, algorithms?
All of that is copyright protectable. The difficult thing with things like code, whether it's software code, HTML code, anything, website coding, the difficult thing with that is that it's always changing. And so you can register sort of what they call your registries, which are good things to register, but you're only protected for the statutory damages up to what you've registered. So anything that's after you've modified it, the modifications aren't going to be protected statutorily. You still have your what's called common law trade or copyright rights, which is quite important and way more helpful than you would imagine. But you don't have the registration for anything that's been changed or modified since then. Does anyone have questions about copyright? Because copyright is a really tricky area. There's a one-sided or two-sided one-page pamphlet on copyright basics that I encourage everyone to take a look at anytime you're creating any content whatsoever. And if you're taking any content from the internet or borrowing or modifying, like she said over here, it has to be substantially modified. So let's say you cut and paste something from someone else's website and you're going to use it on your own website for a marketing tool. And you cut and paste 2 sentences. You're like, this is a great soundbite. You're like, I'm going to change it. I'm going to capitalize that letter. I'm going to change A to the, and I'm going to change being to using. That's not substantial modification. You have to substantially transform the meaning or the purpose of the content in order for it to become your own. If you're just editing the content, editing doesn't mean that the work was transformed. You didn't really do much to it. Yes?
But I do know that there's a couple other cases like fair use.
Yes.
Like if you're commenting on something someone else said, you can do that. If you're parodying something else someone else said or did, you can use that.
Remixes,
Yeah.
mashups.
Yes. And these are all defenses to copyright infringement, by the way. We don't want to have to be defending copyright infringement. I'm trying to teach you guys
but on
how
the
to
other hand, being a writer and creative person, I don't think people should be worried about what they can do every step of the way. And that's an issue, not with you guys, but with a lot of lawyers. They say, well, make sure you don't do this because you could get in trouble. Make sure you don't do this because you can get in trouble. Then you can't do anything because every original sentence, any sentence I say or write, someone else can have that same sentence in their head and they can say it, write it.
Well, and not everything's subject to copyright protection. My legal briefs that I file with the courts, those are creative processes in my mind, but they're not protected.
Yeah, we don't get any credit for any of the work
Yeah.
that we do.
Certain writings are not protected.
And I completely agree with you. And that's why I say just take a look at it. And this is one of those things that you just need to have in the back of your mind. I don't think it should be a limiting factor in what people do. It's just that people need to be aware, especially with the proliferation of the internet and the accessibility of all of this information to just download and pull it all together, people's copyright infringement has just blown up. And I want people here more to be aware of what their rights are if people steal their stuff than what you need to be doing to protect and make sure that you're not stealing from other people. So because we're talking to you as business owners, we want you to know what you can do to protect your works and make sure that your works aren't being stolen by someone else. Yes.
Just on building on something like he went on a different tangent. The government is making a lot of money on like charging people for all these creative work. So do we have any information how much money they are making, where they are spending it, or is it copyrighted by the government? And from so
you can do a FOIA request to the Copyright Office. Absolutely.
Is it available
Freedom
on
of
that
Information
easily?
Act, and good luck actually getting a response.
Getting
Yeah.
such an information,
Yeah,
right?
but
that's how the system is playing against us.
and this is why I told
Making
you
a lot
there's
of money.
not a huge difference, and I said this with the trademarks too, not a huge difference between registering a trademark and not registering a trademark, registering a copyright and not registering a copyright. For the most part, copyright registration, I'm not necessarily going to say that you have to do it. It's only for enforcement mechanism, and it depends on the value of what your project is, right? You have to weigh the cost-benefit analysis. Registering a trademark is a little more important, especially if you're going to launch on a national scale. And it, like I said, it doesn't cost that much to register the trademark. The value of your brand can be astronomical. And if someone seals the value of your brand, the fact that you didn't want to spend the $250 to register your trademark because you were worried it was going to the government, you could lose hundreds of thousands of dollars in business because you didn't want to spend that $250. So that's sort of like a cost of doing business. It stinks, but it's one of those things that you're going to have massive protection for a really small amount of money.
You can also choose to use something like Creative Commons license
Yes.
when you're creating creative works and say, I want people to be free to be inspired by my work and mix it up, do new things with
There's
it.
something like copyleft too. Right?
Yep, that's copy.
Yeah, there's tons of clearinghouses right now that allow you to use freeware stuff. You can even search now through Google Images, and I think
Flickr has
Flickr
it,
switched
and,
over to it too.
What is it? What's the iStock Photo also?
Yeah,
has
you
it.
can just search for anything that's Creative Commons license, and then you're good to go. You don't even have to worry about it.
Just one business point, and that is that there are some differences between registering and not registering a copyright when you get into big commercial transactions where there are lending transactions. Edward and I were talking about this on the ride-in, that if you are fortunate enough to be in a position where you're working on large financing, how a lender will secure an interest in copyrights are different. They will make you register a copyright at that point in time because they will not have the intention without it. So if your business grows large enough where you have those problems, that's great. But understand that some of the stuff we're talking about, as you get into bigger size transactions, maybe different.
Yeah, and again, a lot of these ideas that we're giving you and things that we're talking about are for you to be able to use, I'll be with you in just a second, and keep in the back of your mind as you're growing your business. You know, a lot of these things aren't necessarily worth doing if you're, you know, making 10 grand a year, 30 grand a year. But on a going forward basis, I mean, I think everyone's goal, for the most part, is to expand their business, to be able to grow their business. And so on a going forward basis, whether or not it's for-profit or non-for-profit, you still have to have these protections in place.
So I was wondering how copyright plays against work for hire. So I do video production, and so I keep all the raw footage, and I just happen to put it in my contracts that I retain all the rights to everything that I do, and I license it
and
back.
And whoever's signing that is as dumb as rocks.
Yes. and I give a license to my clients, but I'm wondering, in the absence of that, how does copyright play out?
Work for hire, wouldn't it be?
Right, well, we'll talk, I actually have a slide that talks about all the type of contracts that you can use, but we can jump to that. So, if you are an employee of a company, anything that you create while working for the company is owned by the company. It can be a copyright material, it can be if you come up with a tagline and they trademark it, the company gets to trademark it. If you come up with a process and they patent that process, all of that's owned by the company. You as the employee are their slave, essentially, in terms of intellectual property. You are. In terms of work for hire contracts, so if you're working on an independent contractor basis or a work for hire agreement, work for hire still falls back onto the employer or whoever hired you. Work for hire means I'm hiring you to do this specific task. You understand that this specific task is going to divest back into me, and I will be the owner of this. And that's what the work for hire agreement specifically spells out. If you have an independent contractor agreement without a work for hire provision in it, that's slightly different. You're not an employee, you're an independent contractor. If you don't have that work for hire provision, Renee's getting nervous. If you don't have that if you don't have that work for hire provision in it as the employer, the work goes back to you. You're the one who created the work. You can sell them a license for whatever it is that you've been working on or whatever it is that you created, but you're an independent contractor. You are independently entitled to your independent work processes. That's why it's shocking to me that anyone would, in this day and age, hire you and say, oh sure, you keep all of it, we'll just borrow it from you for a little bit. But if you can get them to do that, it's way better for you as the videographer. Yes?
So then on the other end of that, if you purchase, like if he did a video for me, could I then purchase the copyright?
You could,
from
yeah,
him
he could
if
sell
he
you.
decides to do that?
Mhm.
Okay. And what about this?
And any transfer of copyright, by the way, any transfer of copyright has to be in writing. So you can transfer other things orally, any transfer of copyright has to be in writing or it doesn't count.
And how does that work internationally, like going back to the photographs? I know
We got
you
all
said-
kinds of issues there.
What's that?
We got all kinds of issues internationally.
It depends what country and what agreements are current. table and all kinds of other stuff.
Yes, so there's a bunch of countries that are part of the Hague Convention. They're all agreed to sort of somewhat be bound in theory by our intellectual property laws. But that doesn't mean someone can't just take it from you. The good thing is that a lot of times nowadays they're taking it from you electronically and they're posting it on a website. And so we have what's called the Digital Millennium Copyright Act, the DMCA. And so if someone steals your copyright protected material and posts it on a website, if that website is being hosted in the United States or by a United States host, even if it's being hosted somewhere else, you can do a DMCA takedown notice to the host and they'll remove that material. You're not going to get any money out of it, but you'll at least get that content clawed back to you.
That's like YouTube videos that say this content.
Yeah.
It's also just, if people are interested in that, there's been a whole bunch of closed door trade agreements going on the last few years that the general public has not been privy to. And if that's the sort of thing that interests you, it might be worth looking into, contacting your elected Congress critters, letting them know that it matters to you as business owners and copyright owners.
Yeah, there's copyright, especially in the age of the internet and the global economy, is just a giant mess. You're able to protect it freely in the United States. Once it gets out, it's kind of, I call it whack-a-mole. It's, you smack it down in one country and it pops up again in another country. So it's very convoluted, and that's why you want to make sure that you have your protections in place. And the best that you can do is try to shut it down as it pops up.
And actually the philosophy behind the patent and the system and its origin in the 14th century has completely neglected.
Oh, of course.
So it's
Yeah,
like just a government's tool now.
Yeah, if you read any of the articles on like the Apple Samsung case, it's like some of the articles that are on that case are just really good because they talk about the policies behind our patent and trademark and copyright system and this conflict between innovation and creativity and governance and protecting businesses, and they're really just clashing in this day and age, and that's how that ruling ended up the way that it did because of that clash of systems. And so everyone agrees that it needs to be modified. No one can possibly figure out how to do that.
Because it's a question of values and trust, which is completely gone away because government itself doesn't have any values.
Well, and a lot of the people making the laws don't understand technology where it is. We've gone past simple machinery, which is easier to understand, and into all of you can patent math, which is just patently absurd. I didn't mean to say that. But yeah, like the grasp on what the system needs to cover now is so beyond a lot of the lawmakers trying to address it.
Yeah. So speaking of patents, next of the big five, patent is an intellectual property right granted by your favorite government to the inventor of lots and lots and lots of different types of things, products, items, processes can be patented. Honestly, this is going to sound horrible. I don't really recommend that you patent anything. Unless it is so novel and complex that no one's ever going to come up with it in the next 15 years, even if they look at your patent application. Here's the problem with patents. Personally, my opinion, not the opinions of Jayberg and Wilk, these are just my opinions. If you patent something, once the patent application is published, which it has to be published in order for you to get a patent, once the patent application is published, anyone can modify your patent and then come out with a competing similar product. So they only have to tweak a little bit of your patent in order to have a product that doesn't violate your patent, but is nearly identical and competing. Renee's wincing. To me, patents, there are certain products I think that should be patented, but they are very novel products. We have people who will come in and say, hey, I came up with a toaster oven that does this. You just modified a toaster oven, just go make the product, no one really cares. It's not gonna help you a whole lot if you patent it or not. Plus, patent processes, unlike trademarks and copyrights, crazy expensive. You can spend $30,000 at least patenting something. You have to go to a special attorney. The attorney has to be licensed by the patent bar. I am not a patent attorney. Renee is not a patent attorney. We can refer you to one if you'd like, but they have to take a special test and be licensed by the patent bar, and they just charge crazy amounts of money because a patent application is so expensive. Has anyone here ever actually read or done a patent application? You guys know what a mess those things are. I mean, there's just, whoever whoever decided that this is the process of a patent is just absolutely sadistic. Because you have to go line by line describing things, and you're repeating yourself 427 times over.
It's not the hard part of the patent. It actually the application is the hard part. It's the fact that the patent office generally kicks it back the first time and says, "Are you really serious?" And it's the subsequent reapplications in the lawyer time that will eat up all your money.
Right. And so, whereas, like I said, there are certain situations where patents will be great, and we're happy to tell you, practically speaking, if this is something that you should be patenting, or, and spending your money on that. So, up to
Also, if your plan is to actually make the product rather than just sell the patent to a patent assertion entity and make money off of it, you get prior art. If you actually produce the product and someone else tries to rip it, you get prior art.
Yeah. So there are ways around the patent, but it's an option. It's a good option depending on the type of product or process that you're creating. You just have to think economies of scale, and is it going to be worth it for you to do? And is it something that's going to be so easily replicated once you produce it that it's really not going to help you a whole lot if you go ahead and patent it? Trade dress. Sorry, I'm going to talk really quick so Renee has any time at all to talk. Trade dress is look and feel and just the general overall view of your product, your process, your website, your labeling, things like that. Trade dress is really easy for people to infringe on, but it's not really something that you can do a whole lot to protect other than just be vigilant with your product and with your process. The last one is trade secret. This is going to come into play a lot in these co-working spaces, so listen up. Trade secret is actually defined by statute. It's not just ordinary business information. It's not just something that like generally speaking, yeah, if you're doing this kind of business, you need this, and the other thing. Client lists are a good example of things that are sometimes considered to be a trade secret. If you're in a very general area, let's say you're selling paper, well, every business in the entire United States probably needs paper of some variety at some point in time. So that client list isn't going to be that specific. But if you're selling certain type of medical devices to certain type of doctors who do perform certain types of procedures, that client list could be protected. So certain pieces of information within your business can and should be considered trade secrets. And basically, while you're working with your business and while you're developing your business, anything that you're doing that you're thinking, hey, this is pretty novel. I'm probably the first person, at least the first person around here who came up with this idea or this way of doing things or this person to contact. I should probably make sure that I don't just give this out to everyone else so everyone else can use it. You can if you want to, and that's a fine way to do it. But if it's something that later on you're going to say, maybe I really should have kept this to myself because now everyone's doing the same thing I was doing and I can't make any money on this, then this is something that you should protect as a trade secret. And there's ways to protect trade secrets. The easiest and most obvious way is to say, this piece of information is confidential, and before I give this piece of confidential information to you, I need you to sign a non-disclosure agreement or a confidentiality agreement. That's the easiest, best, safest, smartest way to do it. Password protecting your devices, another way, yes?
So, probably this most is people go off the internet and say, I actually go to a lawyer, or work for people to depend on.
Yes.
And so, yeah.
And that's why Renee, at the end of this talk, will be talking about when to go to a lawyer. Because I think that's a kind of a critical piece of information. By the way, if you also print an NDA off the internet, depending on where you got it from, you probably violated someone's copyright while you were doing that. Different issue.
Can you cover more than one idea on the same NDA?
Absolutely. Yeah, you can say everything I'm giving you in connection with this business. You just have to generally define it enough so that later on you can go back
more
to
than
it.
one business involved.
You should probably do two.
Or talk to a lawyer.
Yeah, or talk to a lawyer. We can craft it, or someone else can craft it. You just have to be specific enough, but general enough. It's walking that fine line. You don't want to say what you're telling them, but you want to define it enough so that they understand later on what you've been enforcing.
Right. The trick with the NDA is that you want to give enough information so that a third party coming in can say, oh, I understood that I was going to be receiving information regarding financials for this year, this idea et cetera, but not so much that you're actually giving away the information in that document. So it is a balance between being descriptive enough and being general enough, right? So you don't want to say, and I've given you, you can say plans and specifications relating to the idea I call
Project X.
Project X, right? That's fine. That's all you need. But don't give them the information before they sign the NDA. That's where people make their mistake. What they do is they give them the information. They say, by the way, I'd like you to sign this confidentiality or disclosure agreement. No. Make them sign the disclosure and the confidentiality and non-disclosure agreement before you give them the information.
The other time it
Otherwise,
comes,
you lose the confidentiality.
yeah, it comes up a lot when someone's like, hey, I'm looking to invest in your business. Can you tell me can you open your books to me? And everyone's like, yes, you want to give me money? Here, look at whatever you want to. And you forget that first step because they're like, oh, great, now I have all this information and you just gave it to me and now I'm going to take it and run and start a competing business because I thought you had a great idea, which is why I wanted to invest in it, but I see you're a horrible business person, so I'm just going to take your idea and go over here and start a competing business with everything you handed to me without putting any protections on it.
Right, so
Well, if your idea said you need coffee, you're probably not going to get money.
Depends. You'd be shocked.
Well, and that was my next point, is that it's called a non-disclosure agreement, but if you really wanted to be more specific about the primary use of these, is that people are not going to use the information. So it's not that they won't disclose it to a third party. I'm not worried about somebody posting it on the internet so much. I'm more afraid that I've approached this person because they can collaborate with me in creating perhaps something bigger or enhancing my business or being an investor in my business. And instead of investing in it and working with me, they said, I like this, and there's no restrictions on my using it. I'm just going to take it and use it for myself. So it's not the disclosure that you're trying to prevent, it's what rights do they have to the information. Again, this is your information, your trade secret, maybe some of it's copyrighted or copyrightable, and you don't want them using it beyond the scope of the use that you're allowed.
So some of the documents and contracts that we talked about, we've sort of walked through these before, but these are sort of the best types of agreements to protect your intellectual property. The NDA, confidentiality agreement, if you're working in a business, you have employees, interns, things like that, and you're worried, you don't have an employee handbook, but you're worried about some of your processes going out afterwards, confidentiality agreement is a great way to protect that information and keep it within your workspace. Independent contractor agreement, same thing. Work for hire, we talked about that. Employee handbook, if you grow and you become a business and you have employees, you should have an employee handbook. And that employee handbook should set out what are the trade secrets of the company? What does the company believe its trade secrets are? It should set out what the rights of the company are in owning the intellectual property of the employees and what the rights of the employees are, or lack of rights of the employees are, in taking any of the information from the company.
Right. I mean, there are many reasons that a larger company will want to have an employee handbook. They'll want to have an employee handbook because it sets out policies regarding vacation time, paid time off, dress codes, drug policies, and all of that. And I'm not necessarily suggesting that for startups and smaller businesses they can need that. What you need, you don't have to have a real book. You just have to have a couple of written policies that guide certain aspects of your business and trade secrets, the information that they're not entitled to share, what type of information they have on their computers, and what information they're allowed to take home with them, as well as any of those kind of policies. So when we say a handbook, you don't have to be that elaborate about it. It doesn't have to be a big, expensive, fancy handbook. It could be a one-page piece of paper. And I want to point out that some people think, well, I'm just going to have an employment agreement, and I'll just put those policies in my employment agreement. I don't recommend that. Employment agreements serve an entirely different purpose. The purpose is to create a longer-term relationship between you as a business owner and an employee. And once you have an employment agreement for a term of years, or whatever that term is, you lose one of the opportunities in Arizona, which is to terminate an employee for cause or no cause at will. So before you create an employment agreement and start thinking, oh, I'll just have an employment agreement, I'll put all my policies in there. Think again, not probably the best thing to do. There's different reasons for both.
Okay, we're now on the leveraging IP slide with the fun guy and the money machine, like I was telling you about and promising before. Yes, everyone's very excited about the money guy. And now Renee gets to talk.
Well, yeah, and this is really one of those slides from where, as a lawyer, I stand up and say, you know, it kind of depends what you want to do. And the rule of thumb is, in leveraging IP, what you need to realize that your IP has value. If you walk up to somebody, you're at some conference, and you say, hey, meet me in my hotel room, and I want to show you my idea, and you write it down on a napkin, and you share it with them, and they then think, yeah, that was an interesting idea, they have a good product, but I think this person's crazy, and you haven't, and they haven't signed any non-disclosure. You've now given your idea away. They can use it. They can approach somebody else with a similar idea and start working with them. So your ideas have value. Make sure that you think of that, because once you give away your idea for free, it's hard to make somebody pay for it. A good example is the newspapers when they started publishing on the internet, and now they want to charge people to access their internet content that they gave away for years for free. They're having a lot of problems with that. So again, think that your IP has value. Have a contract that if you have a contract, you're telling somebody it has value. When you have somebody sign a non-disclosure agreement, you're already telling you, I'm not giving this away for free because I think it has value. And other people respect that. So when we're talking about leveraging your IP, it's recognizing the value, and when you enter into contracts, don't give away for free.
I understand that you can take other people's information that's published and reorganize it and put it in different form and copyright that for yourself. Is that correct?
That's formative works.
Not really.
It's a lore.
Well, it has to do with improving it,
Uh-huh.
making better use of it.
If you're just restructuring it, if you're taking, you've got a 6-paragraph thing and you put paragraph 6 at 1 and 2 at 4,
Yeah.
that's no.
Well, this is taking 3 or 4 pages and condensing them down.
You still probably can't copyright that. That's still probably copyright infringement. Unless you're using it for another purpose. So we're going to go back to the fair use concept. So if you want to analyze it and you want to say, okay, here's this 4-page narrative, and they have this opinion about big government, and here's what I think, and you just take a paragraph of what they said, you copy a paragraph, and then you submit, you've got 2 paragraphs of your own commentary on it, and then you say and then they said this, and this makes no sense to me, and here's why. That would be more fair use. Yes? Got it.
Any questions about the basic contracts? And understand that you can pretty much devise whatever you need for your situation. So if you have something that's not covered, you think, by the standard agreements, and most of these business forms, by the way, are online. You can go online and find employee handbooks, business policies. You just have to think that you want to look for them and craft one that best suits your needs under the circumstances. And just because you created it 5 years ago doesn't mean it works today for this deal. Change it up. So, a couple of different kinds of ways to structure a business. Most common one for startups is sole proprietorships. They start up, they get a name, they have copyright, it's all done in their name. For business purposes, you're all taxed through your individual taxes. And the advantage of a sole proprietorship is it's simple, it's easy, you don't have to file anything. Biggest disadvantage with the sole proprietorship, if you're selling anything or providing a service, is you have no shield or protection. There is no dividing line between your personal assets and the company. So if you are doing something and something gets hurt as a result, they are suing you personally, and if you don't have the money, you personally, you will suffer personally. They will be able to attach any of your personal assets.
And we have some good bankruptcy attorneys if that's the case.
Correct. We have known clients to do that. They didn't approach us first. So when you're thinking about the type of entity, there are a couple of things that I tell people to think about. There's taxes and accounting issues, which you need to speak to your tax or accountant about, and we will work with your tax accountant or your business manager to help you set that up, and that's great. But you want to think about liability. Can I protect myself, and do I have partners, or is this just me? If it is just you, and you want to protect yourself from that sole proprietorship, give yourself the shield. Whether you do an LLC or a corporation, doesn't matter. There's some tax implications, but if it is a mom and pop, or just one person, and you are not relinquishing control or sharing profits or losses, doesn't matter. Commonly these days, people are doing LLCs because the structures are a little easier, but you can choose to be taxed in a variety of ways. So there are some restrictions in the corporations in Subchapter S in terms of who can be an owner of a Subchapter S and whether or not you have to be a legal resident of the United States. So there are some issues there, but for purposes today, we're going to look past that. De facto partnership is over sole proprietorship, either because lawyers just did it that way, but there's a good reason for it to be that way. Sole proprietorship kind of is, well, sole proprietorship is the default, right? I haven't done anything, so therefore you are a sole proprietorship. It is the default. De facto partnership is the default for if you did not do an LLC, corporation, partnership agreement, or a joint venture. So if you are two people working together to develop one company or one product, you are going to be deemed a de facto partnership. And people who think they are not a de facto partnership sometimes find themselves to be one. The implications of a de facto partnership, again, are that partnerships and de facto partnerships there is no liability shield, and partners are personally liable for the debts of a partnership. So corporation and LLC, the individual members, officers, owners, are not directors, are not, absent fraud and other circumstances, not personally liable for the debts of those entities. So if you're an LLC and you can't pay your rent and you did not sign a personal guarantee, you say, I'm sorry, and you walk away. But if you were a sole proprietorship or a de facto partnership or even a partnership, then you can be personally liable. So the fact that you've been successful in other areas or had an inheritance 2 months earlier, that can all be taken by your creditor. So very important to create that shield. The other thing, when you are working with other people, is think about control and management, as well as sharing the profit and losses. So LLC gives you much more flexibility in terms of how you structure your management and control. You can do a variety of things. It is subject to negotiation between parties. Corporations are fairly static type entities. The law is hundreds of years developed. You have a formal structure, one share, one vote. But LLCs, you can vary that, you can play with that. Profits and losses can be split in a variety of interesting ways.
Is there any structure like limited liability partnership of that?
Yes. We don't have limited liability companies. We have on there LLCs. Limited liability partnerships. The difference, well, let me talk about what a partnership is. A partnership basically is two people get together, they put together a partnership agreement, they say, we're going to do this together, and here's how we're going to split profits and losses. And it is a document that you will record with the Secretary of State. It does not go through the Arizona Corporation Commission, as does corporations and LLCs. Joint venture also, and joint ventures just don't get filed anywhere. They're kind of like de facto partnerships that people actually write up documents. But a limited liability, and the different, and a partnership, the general partners, all the partners are personally liable. A limited liability partnership, which used to be very common before LLCs came into being, especially with real estate transactions in Arizona, is slightly different. You have a general partner who is personally liable for the acts of the partnership, and then you have limited liability people underneath. And those are primarily investors. They generally have no control, no voice, no votes, and no liability. And the only thing they are entitled to is a return on their investment. So limited liability partnerships are primarily used in connection with some type of passive investment for the limited liability partnership. And many LLCs are still structured that way. One caveat on LLCs and limited liability partnerships and some corporations is that if you are structuring any transaction in which somebody is obtaining a passive return on their funds, that is a security. You are then subject to both state and federal securities laws. And that is another whole topic, but just keep that in mind if you are taking a passive investment. So, but I do want to talk about one thing because I've had this, and Laura's going to answer. So, yeah, you and I decide to, we meet, and I manufacture products, and you have an idea for design. And we meet, and we decide, we create this new car that nobody has ever seen a car like this.
Flying car.
It's a flying car. And
We're in the 60s.
and we never quite get around to drafting an agreement, but I already have an existing business that sells flying machines, and you manufacture cars, and we're both using the same name. We first say, well, I'm going to sell them and you're going to manufacture them. And you create a manufacturing company and open a new company, and I just keep selling through my own company. But we both use the same name for this new flying car, and it's the Magic Flying Car. Who owns that? It's trademark, right? It could be trademark, right? Who owns that trademark?
Who's on first?
Yeah.
Nope, who's on first? Whoever first used it in commerce.
But we use together, right?
Nope.
No?
Whoever came first. Whoever's first using the mark in commerce for that product.